Good afternoon. We're going to have a little look through the proposed jury instructions, the verdict form. I'm going to start with wayfarers. I'm also going to go through it as if the jury are answering yes, okay? Because if you answer no to certain questions, you can skip ahead to a specified question. But for the sake of being able to go through it, we're just going to assume that the jury have said yes to all the questions. Okay, so again, wayfarers proposal, special verdict form. We, the jury, in the above entitled action, find as follows on the questions submitted to us. Question 1: Did Blake Lively complain about or oppose conduct based on a reasonable belief that she had experienced sexual harassment? So they would answer yes or no. If they answer yes, they proceed to question 2, and if they answer no, they go straight to question 8. So I'm going to assume they say yes, just so we can keep going through the questions, but you will see question 8 when we get there. Question 2: Did Wayfarer Studios subject Blake Lively to an adverse employment action, yes or no? And then go into question 3 anyway. Did It Ends With Us movie subject Blake Lively to an adverse employment action? And that's a yes or no, and then you proceed to question 4. Obviously then, because the claim is against Wayfarer Studios and It Ends With Us movie, so the jury have got to look at both sides. And it may be that they say yes to one and no to another. You know, that happens. That's okay. Okay, so either way, you get to question 4. Only answer question 4 if you've answered yes to either question 2 or 3. If you did not answer yes to question 2 or 3, go to question 8. So question 4: Were Blake Lively's complaints about or opposition to conduct she believed was sexual harassment a substantial motivating reason for Wayfarer Studios / It Ends With Us movies conduct, yes or no? And if you answer yes to question 4, you continue to question 5, but if you answer no, you go to question 8. Question 5: Were Wayfarer Studios / It Ends With Us movies efforts to protect Wayfarer and the film from adverse media coverage also a substantial motivating reason for its conduct, yes or no? And if your answer to question 4 is yes, then continue. If no, skip question 6 and answer question 7. So again, we're going to assume they've said yes. Question 6: Would Wayfarer Studios / It Ends With Us movie have engaged in the same conduct anyway at that time based on its efforts to protect Wayfarer and the film from adverse media coverage had Wayfarer Studios / It Ends With Us movie not also been substantially motivated by retaliation, yes or no? If your answer to 6 is no, proceed to 8. If you have answered yes, proceed to question 7. Question 7: Was Wayfarer Studios / It Ends With Us movies conduct a substantial factor in causing harm to Blake Lively, yes or no? And if your answer to question 7 is yes, proceed to 8. If it's no, then proceed to question 11. So that first set of questions, all the way up to question 8, is about It Ends With Us movie / Wayfarer's retaliation accusations. So this is Blake Lively's claim against them for retaliation. We're going to assume they say yes, and then we go into tag. Question 8: Did tag know that Wayfarer Studios and It Ends With Us movie was going to retaliate against Blake Lively, yes or no? And if the answer is yes, go to 9. If you have answered yes, proceed to 11. I think that's a typo. Yeah, that should be. If you answer no, that should be, but it says yes. So they should file an errata, but that's a typo. So what that means is if you answer no, then proceed to 11. We'll get to 11. Assuming they say yes, question 9: Did tag give substantial assistance or encouragement to Wayfarer Studios or Ends With Us movie, yes or no? If the answer is yes, proceed to question 10. If you've answered no, please proceed to question 11. So, yeah, did Tag give substantial assistance or encouragement to Wayfarer / Ainsworth's movie? The answer to question 9 is yes, proceed to question 10, and if it's no, proceed to question 11. Question 10. Was Tag's conduct a substantial factor in causing harm to Blake Lively? Yes or no? Either way, you proceed to question 11. So now we're at question 11. Now, up to question 8 was questions regarding the retaliation cause of action against Wayfarer and Ainsworth's movie. From question 8 to question 10 was the retaliation cause of action against Tag. Question 11, we are looking, this is going to be asking questions about the breach of contract for the contract rider agreement. Did Blake Lively and Ainsworth's movie enter into a contract? Yes or no? Now, obviously, I'm going to say no, right? Because I've said this. Blakely Inc. entered into a contract with Ainsworth's movie, not Blake Lively, and that is incredibly important. But the jury are going to have to ask, unless Wayfarer raised this during the trial. Hold on a minute. Who signed this contract? Blake Lively. But was she signing it on behalf of herself or, a corporation? Unless Wayfarer raised that, which they may, I've not discounted the possibility that they're leaving the contract rider agreement cause of action in just to go to trial so they can have this whole powwow. Having come this far. Otherwise, Blake Lively's going to say, well, it was all technicalities or, so on and so forth, as she's already tried to do. So I can see what they're doing there. But this is about the cause of the contract claim. Was there a contract between Blake Lively and the Ainsworth movie? If the answer is yes, proceed to question 12. If the answer is no, proceed to question 17. So we'll assume they say yes. Question 12. Did Blake Lively use a wrongful act or wrongful threat to pressure Ainsworth's movie into consenting to the contract? Yes or no? The answer to the question is yes. Proceed to 13. If the answer is no, proceed to question 15. We'll assume they say yes. Question 13. Was Ainsworth's movie so afraid or intimidated by the wrongful act or wrongful threat that it did not have the free will to refuse to consent to the contract into consenting? Wrongful threat that it did not have the free will to refuse to consent to the contract into consenting to the contract. I think someone's going to have to reword that. Yes or no? Basically, you're saying, were they so intimidated that there was no free will to consent? Yes or no? If the answer is yes, proceed to question 14. If no, proceed to question 15. So I assume they said yes. Proceed to question 14. Would Ainsworth's movie have consented to the contract without the wrongful act or wrongful threat? Yes or no? The answer to the question is yes, proceed to 15. If it's no, proceed to question 17. So question 15, did Ainsworth's movie do something that the contract prohibited it from doing? Yes or no? If your answer to question 15 is yes, proceed to 16. If not, proceed to question 17. Question 16. Was Blake Lively harmed by Ainsworth's movie's breach of contract? Yes or no? Proceed to question 17. So regardless of the answer, go to question 17. Only answer question 17 if you answered yes to questions 7 or 16. So let's just go back and look at 7 and 16, just to refresh ourselves. Question 7. Was Wayfarer Studios / Enzo's Movies conduct a substantial factor in causing harm to Blake Lively? And was Blake Lively harmed by Enzo's Movies breach of contract? So if you do not say yes to either one or both of those questions, that's it. You stop, don't answer any further questions, and have the presiding juror sign and date this form. And that would mean then that they do not find in favour of Blake Lively. If they've answered yes to either one or both of those questions, continue. What are Blake Lively's damages? A. Economic damages, which are lost past earnings. Enter the amount below that you find Wayfarer Studios, Enzo's Movie, or Tag is liable to Miss Lively under retaliation, aiding and abetting, or breach of contract. If you awarded any damages, what percentage is related to aiding and retaliation, aiding and abetting retaliation, and then breach of contract? And then economic damages, lost future damages. Enter the amount below if you find that Wayfarer Studios, Enzo's Movie, or Tag is liable to Miss Lively under retaliation, aiding and abetting retaliation, or breach of contract. If you awarded any damages, what percentage is related to retaliation / aiding and abetting retaliation and breach of contract? C. Economic damages, lost profits. Enter the amount below if you find that Wayfarer Studios, Enzo's Movie, or Tag is liable to Miss Lively under retaliation, aiding and abetting retaliation, or breach of contract. If you awarded any damages, what percentage is related to retaliation, aiding and abetting retaliation, breach of contract? And then you got non-economic damages, garden variety, emotional distress. Enter the amount below if you find that Wayfarer Studios, Enzo's Movie, or Tag is liable to Miss Lively under retaliation or aiding and abetting retaliation. And then then go to question 18. Only answer this question if you awarded more than nothing in damages for question 17D, and that's the non-economic damages, garden variety. Otherwise, skip this questioning. Skip this question and go to question 19. If you awarded any damages under question 17D, what percentage of responsibility for Miss Lively's non-economic damages do you assign to Wayfarer Studios, Enzo's Movie, Tag, Blake Lively? Okay. And then others. Question 19. Only answer this question if you answered yes to questions 2 and 7 and awarded more than 0 in damages. So I'm going to go back up to refresh me. What's question 2? Did Wayfarer Studios subject Blake Lively to an adverse employment action? And 7, was Wayfarer Studios / Enzo's Movie conduct a substantial factor in causing harm to Blake Lively? So if you say yes to either one or both, then we are answering this question. But if not, you just continue to question 20. Did Miss Lively prove by clear and convincing evidence that one or more officers, directors, or managing directors of Wayfarer Studios acting on behalf of Wayfarer Studios engage in conduct constituting malice, oppression, or fraud as part of its retaliation? Yes or no? Regardless of the answer, proceed to question 20. Only answer question 20 if you answered yes to questions 3 and 7. So we know what 7 is. Let's go back just for my benefit. Sorry, guys, just for my benefit. Did It End With Us Movie subject Blake Lively to an adverse employment action? And then obviously question 7 is, was the conduct a substantial factor in causing harm, right? And if they answer yes to one or both, answer question 20. Otherwise, continue to question 21. So if you answered yes to either one of those questions, 3 and 7, and awarded more than nothing in damages in question 17, you can answer this. Otherwise, you continue to 21. Did Miss Lively prove by clear and convincing evidence? I'm sorry, I can't even say it without laughing. Convincing evidence. That one or more officers, directors, or managing agents of the Enterprise movie, acting on behalf of the Enterprise movie, engaged in conduct constituting malice, oppression, or fraud as part of its retaliation, yes or no? And then proceed to question 21 regardless. Only answer question 21 if you answered yes to question 10 and awarded more than $0 in damages. So question 10 will be about tag, did tag cause harm, etc. Otherwise, skip question 21, sign and date the form. Did Miss Lively prove by clear and convincing evidence that one or more officers, directors, or managing agents of tag, acting on behalf of tag, engaged in conduct constituting malice, oppression, or fraud as part of its retaliation? That's an interesting choice of words because it's asking the first bit I love, right? Well, I like it all, but did Miss Lively prove by clear and convincing evidence that one or more officers, directors, or managing agents of tag? And then the next part is I was expecting it to say acting on behalf of Wayfarer potentially, because that's the whole argument is Wayfarer engaged tag to aid and abet. But it's not. It says acting on behalf of tag. Why would they do that? I would struggle with that. And then, so anyway, yes, no, and then sign and date the form. Presiding juror, that would usually be the foreman. After this verdict has been signed, notify the court attendant that you're ready to present your verdict in the courtroom, etc., etc. So that is Wayfarer's proposed jury verdict form. We can go and look at Lively's as well, just to kind of see how different it is. Okay, so this is Blake Lively's. The parties have been unable to reach agreement on the proposed verdict form. Accordingly, Blake Lively respectfully submits the following proposed verdict form, reserving the right to propose additional changes and modifications as the trial progresses. Okay. Please follow all instructions, check your answers and fill in the blanks. All answers must be unanimous. So important to she's highlighting like this has got to be unanimous. I think Wayfarer actually are happy for a minority verdict, but Lively's like no, they've all got to agree, and that's that. So we'll see what ends up being the the deciding. The Judge Lyman's going to have to make those decisions on some of this. Okay. 1. Ms. Lively's claim for retaliation in violation of the California Fair Employment and Housing Act. Do you find that Wayfarer Studios is liable for retaliating against Ms. Lively? I think that's a little bit... That's a little bit simple. Yes or no? And then go to question 2. Do you find it Enterprise movie is liable for retaliating against Ms. Lively? Yes or no? And then go to section 3. These are very simple. I prefer Wayfarers step by step. Okay, because Wayfarer are actually looking for meeting the elements. Like, did she have a good faith basis? Lively's like, well, did they retaliate against me or not? And she's not. Her verdict form is not, and I know why, but it's not making sure that step by step all the elements of the law has been satisfied. So Section 2, Miss Lively's claim for breach of contract. Do you find that it ends with us maybe breach paragraph 10 of the protections agreement, which provides, and then she quotes that point number 17. Yes or no? I mean, she's not even asking a question. Was there a contract? Did someone breach it? Was Blake Lively harmed as a result? What is this? Right, so, well, then we go to Section 3. Miss Lively's claim for aiding and abetting retaliation in violation of the California Fair Employment and Housing Act. Only answer these questions if you've answered yes to question 1 or question 2. Otherwise, skip and go to Section 4. Do you find that Tag is liable for aiding and abetting retaliation against Miss Lively? Yes or no? Yeah, I don't like this. This is... Okay, we continue. So we continue to damages. If you find in favour of Miss Lively on her claim for retaliation by answering yes to any question in Section 1, how much do you award damages to Miss Lively? I don't like this at all. Go to question 6. If you find in favour of Miss Lively on her breach of contract claim by answering yes to the question in Section 2 above, how much do you award Miss Lively in damages? Question 7. If you find in favour of Miss Lively on her claim for aiding and abetting retaliation by answering yes to the question in Section 3 above, how much do you award Miss Lively in damages? And then go to question 5. Punitive damages. Do you find that defendant Wayfarer Studios engaged in the conduct with malice, oppression, or fraud? Only answer this question if you answered yes to question 1. If you answered yes, go to question 8. If you answer yes, go to question 8, go to question 9. Otherwise, skip question 9 and go to question 10. What amount of punitive damages do you award against Wayfarer Studios, if any? Question 10. Do you find that defendant Ainsworth's movie engaged in the conduct with malice, oppression, or fraud? Only answer this question if you answered yes to question 2. If you answered yes to question 10, go to question 11. Otherwise, skip question 11 and go to question 12. So what amount of punitive damages do you award against Ainsworth's movie, if any? Do you find that defendant Tag engaged in the conduct with malice, oppression, or fraud? Only answer this question if you answered yes to question 4. God. I am going to go back to Wayfarer's one in a minute because I'm troubled by this. Seriously troubled by this. And to be honest, I think if these get in, it could be something that Wayfarer could appeal on. I'll talk, and that's my opinion, but I'll talk you through why in a minute. So, yeah. If you answer yes to that, what amount of punitive damages do you award against Tag? And then you go to the signatures page, which is here. Each juror who agrees with this verdict must sign below. Obviously, the first signature is for the full person, and then the rest is for all the other jurors because she wants it to be unanimous. So if I just flick back to Wayfarers, right? No, actually, sorry. I'm going to start with Lively's. Let's start with Lively's. Just to compare one question. I mean, so the retaliation has to be based on several things, right? It's only retaliation if it's in response to Blake Lively complaining about sex of acts of sexual harassment within the workplace. But that it doesn't end there. She's got to have a reasonable belief for her basis, right? Judge Lyman went through it in quite extensive detail. It has to be a reasonable belief, and the sexual harassment has to be of a nature. You can't just say, "Well, he called me sexy once," and that's the end of it. It's got to be severe and pervasive. So this is Wayfarer's question form, right? Just to pop back to it. And the first question is, did Blake Lively complain about or oppose conduct based on a reasonable belief that she had experienced sexual harassment? If your answer is yes, and continue to question 2, did Wayfarer subject Blake Lively to an adverse employment action? Because I think everyone's getting lost in this a little bit and forgetting that this is an employment action. It's being treated like it's a defamation claim to some degree, because now the smear campaign has been so prominent in this, right? It's been, even before the sexual harassment complaints were dismissed, it was still very much retaliation, smear, smear, smear. And it was being likened to a defamation claim because, the same thing, again, Johnny Depp case, right? It began with a news article in a prominent, in a prominent news. Oh, I'm forgetting my words here, but that was in the Washington Post, right? A news article in the Washington Post that was shared on social media. But that was not an employment action because obviously they were married anyway. But Amber Heard was sued for defamation. And then she countersued for defamation because of an article that ran in, I can't remember, was it the Daily Mail? I can't remember. Adam Waldman's statements, wherever they appeared, the Sun, the Mirror. And yet, and that is where all this has started here, right? It started in the New York Times, and it's been social media bots, digital smear campaign, digital violence, content creators have smeared me, blah, 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 blah. But everyone keeps forgetting that this is actually what she has brought to the court is an employment action. So her defamation claims have been thrown out as well. She can't even treat it as a defamation claim. And this is why her verdict form is actually irritating me, because it completely overlooks anything to do with employment actions and the legal standards required, such as the reasonable basis for her belief that she was sexually harassed. She wants a simple, well, did they do it or not? And she wants to skip past the important questions, like even if they did it, even if, on the surface they, like here, did Blake Lively complain about or oppose conduct? That's half the question. The answer would be yes, she opposed conduct, but did she have a reasonable belief for that conduct? I think there's a good argument to say no. No, there's not. And then, it's like, I'm going to go back to her, go back to this one a minute. Yeah. Do you find that Wayfarer Studios is liable for retaliating? Do you find it Angela is liable for retaliating? And then she goes straight to the damages. Well, how much are you going to give me? Not was there any harm, right? Because and I'm sorry, I am bouncing back a bit, but I feel like this is kind of important. Okay, so if you answer yes, Wayfarer's form, the next bit they go to is well, were the complaints about or opposition to conduct she believed was sexual harassment a substantial motivating reason for Wayfarer's conduct? Yes or no? And then, if the answer is yes, was it a substantial factor in causing harm to her? Yes. Um, get past the contract. And then the next question, um, let's break down the damages and how much you're gonna give and how much are you apportioning that to, the aiding and abetting and the breach of contract. But Lively's form, this is bugging the shit out of me, to be honest, is literally, did they retaliate against me? Yes? Okay. Great. How much money are you giving me? What the fuck? I'm really annoyed by this, actually. That's just, she's completely skipping over the legal requirements for the claim. And I will be so mad at Judge Lyman if he allows her form to be used. Okay, so those are the individual ones. Now we've got some joint ones here, so we're just going to quickly go through them. The parties have worked collaboratively to propose the following jury instructions. Matters that the parties could not agree upon include each party's position. Okay, so let's go and have a look at this. This is 68 pages. Jesus. Blah, blah, blah. So preliminary instructions to the juries. Members of the jury, now you've been sworn in, I'll give you some preliminary instructions to guide you in your participation in the trial. To begin, you are here to administer justice in this case according to the law and the evidence. You are to perform this task with complete fairness and impartiality and without bias, prejudice, or sympathy for or against the plaintiff or the defendant. It will be your duty to find from the evidence what the facts are. You and you alone will be the judges of the facts. You will then have to apply those facts to the law as the court will give it to you. You must follow that law whether you agree with it or not. Nothing the court may say or do during the trial is intended to indicate or should be taken by you as indicating what your verdict should be. The evidence from which you will find the facts will consist of the testimony of the witnesses, documents, and other things received into the record as exhibits, as well as any facts that the parties agree to or stipulate to that the court may instruct you to find. Where the facts have been stipulated, you must accept those facts as true in this trial. Certain things are not evidence and must not be considered by you. I will list them for you now. First, statements, arguments, and questions by lawyers are not evidence, nor are my own statements to you evidence. Only the answers given by the witnesses and the documents admitted as exhibits are evidence. Second, objections to questions are not evidence. The lawyers have an obligation to their clients to make an objection when they believe evidence being offered is improper under the rules of evidence. You should not be influenced by the court's ruling on an objection. If the objection is sustained, ignore the question. If it is overruled, treat the answer like any other. If you are instructed that some item of evidence is received for a limited purpose only, you must follow that instruction. Third, testimony that the court has excluded or told you to disregard is not evidence and must not be considered. Finally, anything you may have seen or heard outside the courtroom is not evidence and must be disregarded. You are to decide the case solely on the evidence presented here in the courtroom. When you are determining the facts, keep in mind that there are two kinds of evidence, direct and circumstantial. Direct evidence is direct proof of a fact, such as the testimony of an eyewitness. Circumstantial evidence is proof of facts from which you may infer or conclude that other facts exist. The word infer, or the expression to draw an inference, means to find a fact exists from proof of another fact. An inference is to be drawn only if it is logical and reasonable to do so and not by speculation or guesswork. In deciding whether to draw an inference, you must look at and consider all of the facts in light of reason, common sense, and experience. Whether a given inference is or is not to be drawn is entirely a matter for you, the jury, to decide. Circumstantial evidence does not necessarily prove less than direct evidence, nor does it necessarily prove more. Here is an example to help you think about the difference between direct and circumstantial evidence. Assume that when you come in the courthouse this morning, the sun was shining and it was a nice day outdoors. Also assume that the courtroom blinds were drawn and you could not look outside. Assume further that you were sitting here, someone walked in with an umbrella that was dripping wet, and then a few moments later someone else walked in with a raincoat that was also dripping wet. Now, because you could not look outside the courtroom and you could not see whether it was raining, and because no witness testified that it is raining, you would have no direct evidence of the fact that it was raining. But other than the combination of facts that I asked you to assume, it would be reasonable and logical for you to conclude that it was raining. That is all there is to circumstantial evidence. You infer on the basis of reason, experience, and common sense from one established fact the existence or non-existence of some other fact. I will give you further instructions on these as well as other matters at the end of the case, but for now keep in mind that you may consider both kinds of evidence. One of your most important tasks as jurors is to evaluate the credibility of the witnesses who will testify before you. That is, how truthful and believable they are. Listen carefully as each witness testifies during both direct and cross-examination and consider whether the witness is telling the truth. It will be up to you to decide which witnesses to believe, which witnesses not to believe, and how much of any witness's testimony to accept or reject. Now, how do you decide what to believe and what not to believe? You are to listen to the witness, observe their testimony, then decide as you would decide such questions in your own life. Did they know what they were talking about? Were they candid, honest, open, and truthful? Did they have a reason to falsify, exaggerate, or distort their testimony? Sometimes it is not what a witness says, but how he or she says it that may give you a clue as to whether or not to accept that witness's version of an incident or an event as credible or believable. In short, the way a witness testifies may play an important part in you reaching a judgment as to whether or not you can accept the witness's testimony as reliable. Now, a few words about your conduct as jurors. First, during the trial, you are not to discuss the case with anyone, nor are you to permit anyone to discuss it with you. This includes viewing, reading, or posting anything on the internet about the case, whether it be on television, in the media, or newspapers, personal blogs, Meta or Facebook, TikTok, Twitter, or X, or Threads, Reddit, or Instagram, or any other social media or digital platform, even if I didn't list it here. Until you retire to the judgment at the end of the case to deliberate, you are simply not to talk to anyone about this case, including your spouse or partner, family or close friends. Do not even discuss the case with each other until you begin your actual deliberations at the end of the trial. Second, please do not, while you are serving as jurors in this trial, have any conversations with the parties, the attorneys, or any witnesses in this case, whether in the courtroom, in the hallways, in the elevators, outside, or anywhere else. By this, I mean not only avoid talking about the case, but do not talk at all, even to say good morning or to acknowledge any of these people. Someone seeing a juror in conversation with a party, lawyer, or witness might think that something improper was being discussed. To avoid even the appearances of impropriety, then avoid any such contact or conversations. So I can tell you that when the parties, lawyers, or witnesses pass you in the halls without even acknowledging your presence, they do not mean to be rude. They are simply following my instruction. Third, do not read or listen to anything outside the courtroom that relates to this case in any way. Similarly, you are not to allow anyone to speak to you about this case. If you are approached by anyone to speak about it, politely but firmly tell them that the judge has directed you not to do so. If any person seeks to contact you about the case, you are required to report the incident promptly to me by sending me a note through my courtroom deputy, Mr. Fishman. Also, be sure that I am informed if any person you know comes into this courtroom. Also, be sure that I'm informed if any person you know comes into this courtroom. This is a public trial, so that could happen, but it is important that you do not hear from them what may have happened in court while the jury was not present. If you should see a friend or relative come into the court, please send me a note through Mr. Fishman at your earliest and first opportunity. Fourth, do not try to do any research or make any investigation about the case or the issues presented by the case. For example, do not go onto the internet tonight and research any matters relating to the case. Do not call up any lawyer friends to ask about the types of matters at issue in the case. Fifth, I know that many of you use cell phones, smartphones, social media, internet, and other tools of technology. You must not use these tools to communicate electronically with anyone about the case. This includes your family and friends. You may not communicate with anyone about the case on your cell phone, which includes smartphones, through email, text messaging, Twitter, X, Threads, any blog or website, any internet chat room, or by way of any other social networking websites, including Facebook, LinkedIn, and YouTube. Finally, do not form any opinion until the evidence is in. A case can only be presented step by step, witness by witness, until all the evidence is before you. Keep an open mind until you start your deliberations at the end of the case. You are permitted to take notes during the trial. Mr. Fishman is handing each of you a notepad, and you will have a pen with you. Please write your name on the cover of the pad. If you do take notes, please do so only in those pads. Remember that any notes you take are for your use only, and they are only to be used as an aid for your memory. Your memory controls. If you do take notes, be careful not to get so involved in taking notes that you are not listening to the evidence. Once you're in your deliberations, if there is disagreement between one juror's notes and another juror's notes, or between one juror's notes and another juror's recollection, you can ask to have the court reporter read back the testimony, or to have that portion of the transcript sent to you, for it is the official court transcript that controls, not any particular juror's notes. During the course of the trial, exhibits will be received into evidence. They will be marked by exhibit number. If there is an exhibit that you are particularly interested in seeing during your deliberations, write down the exhibit number. At the end of the trial, as you begin your deliberations, we will provide each of you with a list of all the witnesses who testified during the trial, as well as a list of all the exhibits that have been received in evidence. We will now begin the trial. As I told you earlier, the trial is expected to be done by, and that's blank. Let me tell you about the trial day. We will begin each day at 9 a.m. Please be on time. To help ensure that we start on time, please be in the jury room 15 minutes before the start of the trial day so that we may begin without delay. I will add that a light breakfast will be available in the jury room each morning at 8:30. You are not required to take us up on this hospitality, but in my experience, many jurors do. That's nice. The key thing is that nobody be late. If any of you are late, we will have to wait, for we cannot start unless all of you are here. And all of us, myself, the lawyer, the parties, the witnesses, and your fellow jurors will have to wait. And if we lose 10 or 20 minutes every day, we will not be able to get the trial completed on time. As to the rest of the trial day, we may take a brief mid-morning break, and we will take a lunch break at approximately 1 p.m. and we'll take a brief mid-afternoon break with refreshments provided for you. Now let me tell you how the trial will proceed. First, in a moment and before lunch, we will have opening statements. The attorney for the plaintiff will make an opening statement, and then the attorney for the defendants will do so. The opening statements are neither evidence nor argument. They are simply outlines of what the attorneys believe the evidence will show, and they are given to help you follow the evidence as it's presented. After the opening statements and after lunch, the plaintiff will present her case. The plaintiff will call her witnesses, and after each witness testifies on direct examination, counsel for the defendants will have an opportunity to cross-examine the witness. After the cross-examine, there may be a little bit of what we call redirect and re-cross-examination. So redirect is where so like Blake Lively would take the stand, her own attorneys would then question her, then Wayfarer's attorneys would do what's called cross-examination, and then if there was things that needed to be cleaned up or responses to the cross-examination specifically, then her attorneys would come back and do what's called a redirect. But it is not an opportunity for her to testify further about something that hasn't been brought up on the cross-examination. Wayfarer may get to then come back and re-cross-examine her again. So, following the plaintiff's case, the plaintiff will rest. After the evidence is completed and all sides have rested, The attorneys will give their summations. This is the opportunity for the lawyers to summarize the evidence and to give the closing arguments. Following the summations, I will give you instructions on the law. You will then finally retire to deliberate on your verdict. You have a tremendously important task as jurors. It is to determine the facts. You, and not the court, are the sole judges of the facts. The Constitution itself recognizes your role in our system of justice. So please pay careful attention to the witnesses and the evidence received at trial, as well as my instructions on the law. And now we will begin with the counsel's opening statement. So plaintiff's proposed addition. The defendants will then have an opportunity to present their case. The defense witnesses will testify and the plaintiff will have the opportunity to cross-examine them. Yeah, that's fair. Yeah, you should say that. Because that is right. She gets to present herself and her witnesses. The wayfarer will cross-examine, then there'll be redirect, a possible re-cross-examination, and then that'll be her side done. But wayfarer also get to bring in then their own defense. It could even be Blake Lively herself. It would certainly be Justin Baldoni, Jamie Heath, etc., where they will be questioned by their attorneys. Lively's team get to cross-examine. There'll be redirect, possible re-cross-examination, and then the defense will rest. And defendants are saying the same, pretty much proposing the same addition. At the conclusion of plaintiff's case, the defendants may introduce evidence and plaintiff's lawyer may cross-examine the witnesses. Because plaintiff has the burden of proof on every claim, the defendants are not required to introduce any evidence or to call any witnesses. If defendants introduce evidence, plaintiff may then present rebuttal evidence. So if wayfarer bring in evidence, they don't have to, because they're right. Lively has the burden of proof. But if they do, Lively is entitled then to bring in evidence, any evidence that exists that rebuts their position. Basically, what's the word? Not counters. Contradicts wayfarer's position. That backs up and supports Lively's position. They're carrying on here again. So Lively now has then come back to and responded to wayfarer's proposed instruction and said plaintiff disagrees that defendant's proposed instruction is appropriate and has proposed alternative language above. Defendant's position. The jury needs to understand from the outset that Lively has the burden and defendants do not need to put on a case. Defendants do not have the burden on affirmative defenses unless and until plaintiff carries her affirmative burden. Oh, wow, I mean, talk about cat fights. They really do bicker like children, don't they? Okay. There's a lot of instruction. Oh, God. All right, I said we go through it. We're going through it. So, introduction. Members of the jury, you have now heard all the evidence. So, this is at the end. You have now heard all the evidence as to the claims by plaintiff Blake Lively against defendants Wayfarer, Ainsworth's movie, and Tag. You have paid careful attention to the evidence, and I'm confident that you will act together with fairness and impartiality to reach a just verdict in the case. We are near the point where you will undertake your vital function as jurors of deliberating. Now that the lawyers have made their closing arguments, I'm going to instruct you about the law that governs a case. There are 3 parts to these instructions. First, I will provide you with some general instructions about your role and how you are to decide the facts of the case. These instructions would apply to just about any trial. Second, I'll give you some specific instructions about the legal rules applicable to this case. Third, I will give you some final instructions before you begin your deliberations. Okay, I'm going to skim this bit because it's just like, oh, listening to this can be difficult, blah, blah, blah. Thank you for your patience, your cooperation, etc. So you will have copies, etc. I'll be distributing to you the verdict form, which we've just seen the 2 proposed examples of, the competing examples. So general instructions, it talks about the role of the court, don't need to go into that. We know that. The role of the jury, again, we know what that is. Role of counsel, objections and sidebars. We should know what that is. Obviously, we know what counsel is. Objections are, attempt to lodge an objection where they think something improper is taking place, whether it be evidence is trying to be entered improperly, or a question is leading, or that kind of thing. Or it might be that they try to touch upon a subject which has been, which is a part of a motion in limine. Sidebars, that's where they're like, Your Honour, may I come to the bench? And then they have a private discussion. It is still taken down by the court stenographer, so there will be a record of it. But the court does not hear it, the parties do not hear it, the jury do not hear it. But it's like, Your Honour, I really want to talk about this, and she's opened the door for it. And then the judge will make a decision there and then on, yeah, okay, you've opened the door, fair enough. You are free to ask questions, or no, we are staying firmly away from that. And it's those kind of discussions. It's just like small mini trials, in front of the judge to say, look, can we do this or not? Basically. Juror oath, sympathy or bias. I mean, I think that's pretty self-explanatory as well. All persons equal before the law. So, yeah. All litigants are equal, despite Blake Lively's belief. All companies, big or small, are entitled to the same fair consideration as you would give to any other individual party. This means that you must treat Blake Lively, a natural person, and corporate entities, Wayfarer Studios, Enzo's Movie, and Tag, as equal above the law. So, yeah, judge is saying, look, she's an individual on her own, and these are three corporate entities, but you are to treat them as equal. The wealth of the parties. In reaching a verdict, you may not consider the wealth or poverty of any parties. Remember, this has not been signed off on by Judge Lyman yet, right? These are proposed, but I think everyone's going to be okay with it. Burden of proof, preponderance of the evidence. He's saying here, plaintiff Blake Lively has the burden of proving all the elements, and this is what bugs me about her jury instruction form, is she doesn't go through the elements of the actual causes of action she's bringing. She's like, did they do it or not? And if so, how much are you giving me? I don't like that. Especially as it is her that has got the burden of proof. And that's why Wayfarer are like, right, let's go through that step by step. Did she get this? Did she hit this? Did she hit this? She don't want to do that. Explains preponderance. Plaintiff, right, so plaintiff's proposed second paragraph. The burden of proof. What's the second of proof? Some of you may have heard of proof beyond a reasonable doubt, which is the proper standard of proof in a criminal trial. That requirement does not apply to civil case such as this one, and you should put it out of your mind. So what she wants to put in there is, the burden of proof in this case is generally a preponderance of the evidence. Ms. Lively is also seeking punitive damages in this case, and the burden of proof to determine liability for punitive damages is clear and convincing evidence. I will instruct you on what that burden requires later in the case. Defendants' suggestion is, so Wayfarer's suggestion is, the burden of proof in this case is generally a preponderance of the evidence. Certain issues are subject to a higher burden of proof, as I will instruct you further. Defendants also seek to add a sentence to the end of the instruction. Some facts must be proved by a higher standard known as clear and convincing, which I would, I think that's a fair thing, because Lively doesn't want to differentiate to say that clear and, and explain that clear and convincing is actually a higher standard than preponderance. So Lively argues with it. The language suggested by defendants is too argumentative. Really, you're arguing? The court should defer to the jury instruction language regarding what a burden of proof is. Further, the burden of proof instruction, as initially proposed, has already been vetted and used by Judge Lyman. Judge Lyman, you're in my pocket. Plaintiff is amenable to including a clear and convincing instruction in connection with the punitive damages instruction and has included the CACI version in line below. Defendants. It is inappropriate to refer to punitive damages in this section. Defendant's language is more neutral and notifies the jury that certain issues are subject to a clear and convincing standard. That's fair. Affirmative defense. Plaintiff's proposed instructions she doesn't have one. So Wayfarer's proposed instruction on affirmative defense. In this case, defendants have asserted certain affirmative defenses to plaintiff's claims. Even if the plaintiff proves all of the essential elements of her claims, the defendants can still prevail in this case if they prove an affirmative defense by preponderance of the evidence. Yeah, because preponderance of the evidence works the opposite way too. They can defend their claim to the standard of preponderance of the evidence. When more than one affirmative defense is involved, you should consider each one separately. I caution you that the defendants do not have to disprove plaintiff's claims by a preponderance. She always has an affirmative obligation to carry the burden of proof on her claims. But if the defendants raise an affirmative defense, the only way they can prevail on that specific defense is if they prove that defense by a preponderance of the evidence. Plaintiff's position, because she's arguing back. Plaintiff maintains that this instruction is confusing and misleading. No, it's not. And simply not accurate. Yes, it is. Defendants do not have any affirmative defenses as to liability. The affirmative defenses are only as to damages. It is not proper to instruct the jury on what the defendants don't have to do in the context of explaining the plaintiff's burden. Defendant's position. Defendants are entitled to instruction on affirmative defenses. Defendants assert a duress affirmative defense to plaintiff's breach of contract claim. Yes, they do. Duress. Multiple defendants and claims. So there's no plaintiff proposed instruction. Defendants have quite a lengthy one, which the plaintiffs will argue about. In this case, the plaintiff has brought claims against multiple defendants. In reaching a verdict, you must bear in mind that each of the defendants is to be considered separately for each of the plaintiff's claims brought against that defendant. Your verdict must be reached solely on the evidence or lack of evidence presented against each defendant for each claim without regard to the alleged liability of the other defendants. The case against one defendant stands or falls upon the proof or lack of proof against that defendant alone. You must also give separate consideration to each claim in this case. Yeah, you do. The plaintiff has brought multiple claims. It does not follow that if plaintiff is successful on one of her claims, she must succeed on all of them. Similarly, if you determine that the plaintiff has failed to prove the required elements of any one of her claims, that does not mean she has failed to do so with respect to any of her other claims, except as I specifically instruct you. You must consider each claim and the evidence that bears on that claim independently of all other claims, again, except to the extent that I instruct you otherwise. I think that's fair and reasonable. Lively. Plaintiff's proposed instruction is not accurate or appropriate instruction for this case. Plaintiff asserts that Wayfarer and Ends With Us are a joint or are a single or joint entity for the purposes of fee-how retaliation claim. Further, if the jury finds fee-how retaliation, they can certainly determine that is sufficient for the contract claim. No. Which simply prohibits retaliation generally. This overstates their obligation. So she's proposed an alternative. We would be amenable to add in the following language on the single integrated entity instruction. If you do not find that Wayfarer and Ends With Us movie are a single integrated enterprise, then you must separately determine the liability of each entity for retaliation under the fee. You can't say that they are a single integrated enterprise. They're not. Defendant's position. Plaintiff's assertions are simply assertions and cannot be taken as an instruction on the law. Wayfarer, Ainsworth's Movie, and Tag are separate entities and entitled to separate consideration by the jury. Plaintiff has also brought claims against Ainsworth's Movie on 2 different legal theories. Wayfarer and Ainsworth's Movie are legally distinct. Moreover, as the court observed in its summary judgment ruling, plaintiff has abandoned her alter ego arguments as to those entities. Oh yeah, because she was trying to keep bringing an alter ego argument. She just ditched it. So then they go through the what is evidence and what is not evidence. I won't go through all of that in detail. Direct and circumstantial, inferences, witness credibility. I mean, we've gone through some of that already with the opening statement. Failure to explain or deny. There is a proposed instruction from the plaintiffs. If a party failed to explain or deny evidence against him or her when they could reasonably have expected to have done so based on what they know, you may consider their failure to explain or deny in evaluating that evidence. It's up to you to decide the meaning and importance of the failure to explain or deny evidence against the party. Defendants didn't take a position on the proposed instruction. Sorry, they didn't have a proposed instruction. But plaintiff's position, this is a standard instruction provided for in the CACIs, and that the jury must be instructed on in this case, given the evidentiary arguments plaintiff has made consistently throughout the case, including but not limited to in her spoliation motion. If plaintiff's spoliation motion is granted such that the court orders a specific spoliation instruction, we can revisit this instruction. For the love of God, Lyman, just deny it already. Defendant's position. This instruction is argumentative, confusing, and unnecessary under the CACI instructions. The instruction is premature at this stage. Inference from evidence of intent or planning. Okay, so that's just, you may consider evidence that a party intended or planned to take a particular action. If you find that a party, after deliberation, expressed an intention to plan to act, you may infer that the party carried out that action. Whether to draw this inference and how much weight to give it is for you to decide based on all the evidence. Defendants don't have a proposed instruction. Okay. I'm not going to go into too much more of this. So it's just about how to treat witnesses, expert witnesses, deposition, testimony, etc. Retaliation. I'm going to do a separate video, I think, from this point on, because it's a lot. But this is actually specific instructions, like what does this mean? What does this mean? I think this is actually important. The rest is more your generic jury instructions from the judge at the opening of the trial and at the closing of the trial. So this going forward is right, like we've seen in interrogatories and things like and subpoenas. This is what this term means, and by when we say this, we mean this, and that's what some of this is, and they're going to haggle over the definition of some of the terms. And it's going to be an incredibly long-winded video, and I'm already just gone an hour in. So I'm going to stop it here, and I'm going to do this as a separate video, I think, on its own. But do come back and watch it, because I think this will be interesting, and I think it's going to be a real sort of cat fight between the pies.